Welcome to the class, students. Settle down, please. Today we are discussing a very important question for your upcoming KSLU examinations under the Indian Contract Act. The exact question we are solving today is, explain the rights of surety and discuss the various modes of discharge of surety. Now, students, please understand this is a highly scoring area. I want all of you to secure full marks here, so pay close attention to every single point.
Before you write your detailed answer, you must draw this exact synopsis structure in your answer booklets. This is how you secure top marks from the examiner. Write it down. Point 1, Introduction. Point 2, Rights against principal debtor. Point 3, Rights against creditor. Point 4, Rights against co-sureties. Point 5, Modes of discharge. And point 6, Conclusion. Remember, a well-structured paper is always a high-scoring paper.
Let us start with the introduction. Please write down this definition exactly as given. A contract of guarantee under the Indian Contract Act 1872 involves three parties: surety, principal debtor, and creditor. While the surety undertakes a secondary liability, the law provides him with several rights and protections, along with circumstances under which he may be discharged from liability. To put it simply, there is the creditor who lends the money, the principal debtor who takes it, and the surety who gives the guarantee. But underline this specific phrase, secondary liability. The primary burden is always on the debtor. This is a very important concept to grasp right from the beginning.
Now, move to the core of the answer. Start a fresh, bold heading in your exam scripts, Roman numeral 1, Rights of Surety. Under this heading, you must write that the rights are classified into three distinct categories based on who the right is exercised against. Let us examine the very first category.
Write this under heading 1, Rights against principal debtor. Listen carefully and note this down. Point A, right of subrogation under Section 140. After paying the debt, the surety steps into the shoes of the creditor. Students, I want you to underline that exact phrase. Steps into the shoes is a scoring point. Examiners actively look for this phrase under Section 140. Because of this, the surety can exercise all rights of the creditor against the debtor. Next, write point B, right to indemnity under Section 145. The surety is entitled to recover all lawful payments made from the principal debtor. Simply put, whatever legal amount the surety had to pay from his own pocket to clear the debtor's default, he has every right to claim it back. It is that straightforward.
Let us move to the second category, rights against creditor. We will cover this in two parts. First, point A, right to securities, Section 141. Write this down. The surety is entitled to the benefit of all securities held by the creditor. If the creditor loses securities, the surety is discharged to that extent. This is very important for your KSLU examination. If the creditor holds a physical asset as security and negligently loses it, the surety's liability reduces along with it. Losing a security directly links to the surety escaping their liability up to the value of that lost asset. Continuing with rights against creditor, Part 2. Kindly note this down carefully. Point B, right to set off. The surety can claim the benefit of any set-off available to the debtor. In simple terms, if the creditor actually owes some money back to the principal debtor from a completely different transaction, the surety can ask for that amount to be deducted from the current guarantee. Then, point C, right to request creditor to sue debtor. The surety can ask the creditor to legally proceed against the principal debtor. You must write these distinct points separately for better marks.
Now, students, focus here. This is a highly scoring point, a golden case law that you must underline in your answer sheet. Case law, State of Madhya Pradesh versus Kalaram. The court held that if the creditor loses securities, the surety is discharged to that extent. Memorize this name, State of MP versus Kalaram. Use this case law for better marks as it perfectly illustrates the right to securities under Section 141 that we just discussed. Do not forget it.
The third category of rights is heading number 3, Rights against co-sureties. Let us go through it. Point A, right to contribution, Section 146. Co-sureties share liability equally. Point B, right in case of different liabilities, Section 147. Contribution is proportionate to agreed liability. Please write these sections exactly as they are. To understand the difference, under Section 146, if two people guarantee a 10,000 rupee loan together, without any specific conditions, they share the burden equally, a strict 50-50 split. However, under Section 147, if they specifically agreed to different maximum limits in the contract, then their contribution is strictly proportionate to those agreed limits.
Excellent. We are now moving to the second part of our main question.
Give this a fresh heading in your script, Roman numeral 2, Modes of Discharge of Surety. This addresses how a surety can be legally freed from his obligations. You must clearly explain these 5 specific ways a surety escapes liability. Let us examine them one by one.
The first mode of discharge is by revocation. Write down point A, revocation of continuing guarantee, section 130. This is done by notice for future transactions. Then point B, by death of surety, section 131. This discharges liability for future transactions. Now students, please understand this very clearly. Revocation under sections 130 and 131 applies exclusively to future transactions. It never applies to past transactions. Even if the surety passes away, his legal heirs are still liable to pay for the loans already dispersed. The revocation only stops the guarantee for new, future advances.
The second mode is heading number 2, by conduct of parties. Write down part 1 exactly like this. Point A, variance in terms, section 133. Any change in the contract without the surety's consent leads to discharge. Point B, release of principal debtor, section 134. If the debtor is released, the surety is discharged. Listen carefully, the absolute key word here is consent. If the creditor and debtors secretly change the interest rate without asking the surety is instantly discharged. A contract of guarantee relies strictly on its original terms. Without consent, any variance completely breaks the contract.
Continuing under conduct of parties, we have point C, arrangement with debtor, section 135. Write this format exactly into your notes. If the creditor gives time or gives composition, the surety is discharged unless consented. So, what does this mean practically? Giving time means the creditor officially extends the deadline for the debtor to pay, delaying the surety's right to step in. Making a composition means the creditor agrees to settle the debt for a smaller, partial amount. If the creditor does either of these behind the surety's back, without their explicit consent, the surety walks away completely free.
And here is your second important case law for today's lecture. Write it clearly. Case law, Holm versus Brunskill. It was held that any variation in contract without the surety's consent discharges the surety. I repeat, the examiner will deduct marks if this famous case name is missing when you write your variance argument under section 133. Holm versus Brunskill is the foundational bedrock of the rule that you absolutely cannot alter terms without the surety's permission. It is a mandatory point to include.
Moving rapidly to our next modes, write these sections down clearly. Heading number 3, by impairment of surety's remedy, section 139. If the creditor's act prejudices the surety's rights, it leads to discharge. Next, heading number 4, by loss of security, section 141. If the creditor loses security, the surety is discharged to that extent. Now students, notice how the law interconnects here. You have already seen this rule of losing security when we discussed the surety's rights against the creditor earlier. This overlap makes it very easy to remember for the exam. It is a right, and when the creditor violates that right by losing the security, it automatically becomes a mode of discharge.
Our final mode is heading number 5, by invalidation of contract. Please write down this exact phrasing. If the contract becomes void or illegal, the surety is discharged. This is pure common sense, but it is a required point in your answer. If the original contract of guarantee was obtained by fraud, misrepresentation, or if the underlying transaction suddenly becomes illegal due to a change in law, the contract is void. A void contract naturally invalidates the guarantee, letting the surety go completely free.
Finally, students, every top-tier exam answer needs a solid conclusion. I will dictate this closing paragraph, so take it down word for word. The law of guarantee balances the liability of surety with adequate rights and safeguards. While the surety undertakes responsibility for another's debt, he is protected through rights like subrogation and indemnity, and can be discharged under various circumstances to prevent injustice. That is your complete, perfect answer. Keep these points clearly structured in your exam, remember to underline the case laws, and you will definitely score very well. I leave you with this thought. Even with all these strict legal shields, stepping in as a surety is a heavy burden in the real world. Think carefully on these principles as you prepare for your legal careers. Class dismissed.